get my money.
Being out is better than being in. So, you know, I take the bad with the good, but it's not easy.
An innocent man who was freed by DNA tests. A John Doe who reached out to Megan Kanka's mother. A one-time resident of death row who went public. Just 3 of the exclusive stories from the first Due Process season. Just 3 will be updating for this, a special edition. A look back and forward on the docket this week for Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.
If you've been with us for the last 15 weeks, you've joined us on a journey behind the badge, behind the bar, even the bench. I'm Ray Brown, and what we've tried to bring you is an inside look at our legal system through the eyes of a longtime criminal defense lawyer, that's me, and a longtime reporter on social and legal justice. That's our senior producer, Sandra King.
And since today we wrap our first Due Process season, we thought we'd look back at where we've been. We start with one of our first exclusive stories, one that may still be our most compelling.
I think they wanted somebody, and they found somebody, and that's the bottom line.
David Shepard, at first glance, would seem a kind of ordinary guy. He's a maintenance man at Newark City Hall. He's a father and a football coach. But there is nothing ordinary about his story. David Shepard spent more than 11 years in state prison, virtually his entire adult life, for a rape that he did not commit.
Presented an alibi to the jury, and he got convicted.
Convicted and sentenced to 30 years in state prison. And David Shepard would still be behind bars if he hadn't spent so much time in the prison library.
I have read about a guy in California, how DNA had helped him get released from prison.
And you thought maybe me.
Yeah, and that's when it dawned on me. That was 8 years ago.
But more than a decade of wrongful imprisonment was not all that David Shepard had to suffer. You might suppose that Shepard had one hell of a case, the kind that could have at least made him some money.
You would have thought that, and in fact, had he been in another state, had he been right across the river in New York, David Shepard would have had a case, would presumably have made some money. Instead, as we know, there has been an effort. Barry Scheck, who was our guest on this show, took up the David Shepard case, and what's happened?
Absolutely nothing. Not for any fault on Barry's part, but because our Constitution prohibits special bills, and unlike states like New York and Ohio, which have made special provision for people who've been wrongfully convicted, there is no special statute in New Jersey that would give David any kind of a basis for litigation and some kind of recompense.
You'll recall that David Shepard, Barry Scheck said, might have a chance at a private bill if there was a legislator who wanted to sponsor it. We have since found out that private bills in New Jersey are not legal. So it seems, Ray, like David Shepard, while he has some very good things in his life, he still has his job, he has a second baby on the way, he has his freedom. But what he doesn't have is any cash compensation.
That's true, and it's an unfortunate development. Perhaps the legislature is going to look and make some changes in terms of the future. David really was a victim, but he's not the only ex-con who thinks of himself as one. Since last year, New Jersey has something called Megan's Law. Its most controversial point, the provision that sex offenders who've served their time have to register with police and in cases deemed most serious, face the door-to-door notification of their neighbors.
And Ray, again, we were able to tell the story firsthand, not only with the help of Megan Kanka's mother, but with this exclusive interview with one of the men who falls under Megan's law, one of the men who calls himself John Doe.
He's one of nearly 3,000 in New Jersey, all convicted sex offenders who share the alias John Doe.
I've got a lot of sympathy for her, but I just don't think it's fair to a lot of people.
Not fair to you.
To me and a lot of people.
And this is the woman he'd like to confront. It was the murder of her daughter in July of '94 that led just 3 months later to what the country now knows as Megan's Law.
The best thing that they can do is lock them up and throw away the key. But they're not doing that. So if they're not going to do that, at least let us know who they are so we can watch them.
Megan's mother believes her child might still be alive if she'd been able to protect her from the man across the street, a twice convicted sex offender accused of her rape and murder. And though the house that haunted Maureen Kanka has given way to a park that bears her Megan's name, she is the last person that John Doe could convince that Megan's Law is unconstitutional and unfair.
But Megan's Law is still under fire, and though it's been upheld by the state Supreme Court, it's been stayed in 2 cases by a federal court judge who says it's just not constitutional to, in effect, assign new punishment well after sentencing and incarceration.
Raymond, the federal court judge who has stayed those 2 cases, ironically, is known as a pretty tough guy when it comes to sentencing. His position is that you simply can't punish someone twice. You can't punish someone ex post facto. What then do you expect to happen? Because that's very much at odds with what our state Supreme Court has said. The court has said Megan's Law is a go, and in fact, we're already registering people and notifying their neighbors.
Well, on the one hand, you have this judge. On the other hand, you have the state Supreme Court and much of public opinion in New Jersey. If the judge prevails, then effectively it's going to wipe out this program, sending it back to the legislature. The people, of course, who've already had their notification sent out, there's not much you can do to put that wine back in the bottle.
Let me put you on the spot. You're a constitutional expert yourself. How do you see this coming down? Do you expect that, in fact, this will, first of all, eventually get to the U.S. Supreme Court? And will it finally be deemed, no matter how emotionally satisfying, unconstitutional?
Hard to separate my wishes from my predictions. I agree with Judge Gibbons that this law is unconstitutional. I would bet that it'll go to the United States Supreme Court, but if it does, I think there'll be, from my point of view, a bad result.
Ray, as for the man accused in the Kanka case, his trial's been put on hold since we first did our story. The state plans to seek the death penalty in that case, and Mrs. Kanka says that if he's convicted, she wants to be heard in the penalty phase of his trial. Now, that would be allowed under a law passed last year, but an Essex County judge has called the law unconstitutional. So it's now in the hands of the state Supreme Court.
Sandy, that's just the latest of the controversies that still surround capital punishment here. There's probably no law that stirs more opinion and emotion. So naturally, the death penalty was on our docket this season. And we began our coverage with another exclusive, this time a man who could speak firsthand of how it felt to be a resident of death row.
It was scary.
In 1987, Raymond Keiss became one of the more than 40 convicted killers sentenced in New Jersey to die by lethal injection. But 8 weeks later, he became one of the more than 30 to have their sentences overturned or thrown out, changed to life in prison. And last year, still insisting he was innocent, he was finally retried, found guilty only of conspiracy, released for time served. But he's haunted still by his time on the state's most chilling cell block.
You would stay in the cell about 23 hours out of the day. You'd get like a half-hour recreation. You would take a shower, but when you left the unit and you went to like the clinic in the prison and everything, all movement stopped throughout the prison and you were in handcuffs and shackles.
And conversation on death row, he says, was as grim as the future they all faced.
How long they've been on death row, how long they've been in the prison system, if we're ever going to be sent, executed.
Well, several of the men who are on death row with Raymond Keiss are there still, but one who didn't get there until years later could become the first to be killed in New Jersey by lethal injection. John Martini says he'd rather die than live on death row through more years of appeals. A judge has said okay, but Ray, it is not over yet, is it?
Well, this one's clearly going back to the Supreme Court, and this has an interesting configuration. You have Martini, represented by counsel, asking to be executed. The public defender, his prior lawyer, now taking the position that he should not be until all the issues related to his sentence are fully litigated. That's going to go on for a while.
And the lawyer who is arguing that, in fact, he has the right to make this decision to die is someone who's anti-death penalty. So it's all very complex. It's also interesting that if Martini is the first to die, he is white, and yet the hue and cry over death penalty for so long has been that, in fact, there is a bias that blacks are more likely to be sentenced.
Well, it's more than just a hue and cry. A committee for the Administrative Office of the Courts, preparing a study commissioned by the courts, has found that blacks are 10 times more likely to be executed. Now, that's an issue that obviously might work to the advantage of the 6 blacks currently on death row, but there's some precedent for the court being able to reach out and say, any penalty that's so tainted by possible racial bias, we won't accept with respect to anybody. So that's an issue that may work to the advantage even of Marshall, who's one of the other white men on death row.
Wait a minute. There are 10 men on death row right now, 6 black, 4 white, and you're saying that the 4 white may in fact get, if not off of death row, at least many more years added to their possibility of escaping death?
Well, certainly the issue will be up in the air, and while it's hard to predict what our court will do, it certainly is precedented in terms of legal thinking for a court to come to the conclusion that even though these men are white, having concluded that this penalty is infected by racial attitudes and racial bias, that it isn't constitutional to have such a penalty. Now, that's kind of out there at the further end of the spectrum in terms of possibilities, but I certainly wouldn't dismiss it. Most likely that there'll be a long time yet before anybody gets executed, and that there'll be certainly additional hearings with respect to the 6 blacks on death row.
Let me ask you to make another call, and that is, we talked about Megan's alleged killer, his case being on hold. They won't even try him until there is a decision made on a case that was heard just a few weeks ago, and that is the Supreme Court now having to decide whether the families of victims have a right to be heard in penalty phase, just as, in fact, the families of the defendants are heard. What do you think the court's going to say about that?
Difficult to say, because there isn't really a track record of our court dealing with that issue. Certainly there is precedent going back a long time for the families of the defendant to be heard. A very difficult hurdle, I think, for the victims, and I wouldn't assume that this is going to happen.
And finally, this question of whether, in fact, there is bias and who gets the death penalty. In New Jersey, given the fact that the numbers are not as askew as they are other places, and the first 2 guys are white, how do you see it?
60% is pretty askew, 10 times more likely, very askew. It strikes me that underneath all this is the sneaking suspicion many have harbored that really this court doesn't want to have a death penalty, but I don't think that's the case.
Race, in fact, was a theme that ran through most of our shows, just as it runs through the system, but never more than in the case of Claude Coleman, the Newark judge who in just one day went from respected pillar of the community to reputed criminal, falsely accused.
My life has become defined by that particular week. It seems like now I'm the judge who got arrested in Bloomingdale's.
It began 2 years ago in Bloomingdale's, just 14 days before Christmas, when this municipal court judge went on what should have been a routine shopping trip. By the end of that week, there was a formal apology, an acknowledgement that the judge was simply a customer who became an innocent victim. But in between, there was an arrest.
I had no idea what was happening.
And the shockwaves traveled throughout this city, where Claude Coleman, who had started out as a cop, came to run the state's largest fire department, then police department, landing finally on Newark's municipal bench. So Coleman says if any black man should have been safe in an upscale suburban shopping mall, it should have been he.
It is frightening, too, to think that it could be done to someone so easily.
But Claude Coleman's story wasn't just about race. It was also about personal injury suits. He had one of the more unusual ones pending. It was set to go to trial, but the case never did get to the jury.
In fact, he came very close to having this case tried, even though when we did the show, our guests agreed that this would be one hell of a difficult one for a jury to decide. In fact, at the last minute, there was a settlement, but we don't know how much.
It's true. The judge and both parties have agreed to keep the amount sealed. There's all kinds of speculation as to why, but what was interesting was they were literally on the courthouse steps when that case settled.
Judge Coleman had said that he really hoped that there would be some further fallout other than money in his pocket from all of this. Do you think that there is?
It's hard to say. You know, I go back to the Donovan case that we've discussed on the show previously, where Ray Donovan said, where do I go to get my reputation back after a jury had acquitted him? If it's true, as Judge Coleman says, that his reputation will never be the same, and he'll always be the judge who was arrested, for some injuries there is no compensation.
In fact, Claude Coleman said it was his reputation that would never recover, but we saw some other kinds of actions this season where some other kinds of harm were claimed, like the claim of sexual harassment, one some actor friends helped us to illustrate.
Well, I really don't think that's any of your business, Joe.
Come on, Liz, what does Harold have that I don't have?
Well, for one thing, he doesn't annoy the women he works with.
Annoy? I like you, Liz. I care. I want to take care of you.
Take care of me? Don't forget, I make more money than you do.
This isn't about money. It's about caring, Liz. I mean, what about this weekend?
Oh, Joe, please don't start with me. Not on a Monday morning, and I have got tons of work to do. See ya.
Harold doesn't have to know.
So was that sexual harassment? Probably not, since the man in our little drama, no matter how annoying, held no employment or economic power over the woman. But on the very day we were doing that show, some real allegations surfaced against one of the state's most prominent politicians. And Chuck Hytaian was the superior of the GOP staffer who says he harassed her.
And in fact, since we did the show, that woman held a news conference, filed formal charges. Mr. Hytaian turned around and responded with some charges of his own news conference. And interestingly for us, the two guests whom we just by coincidence had have both wound up in this case.
That's right. Both lawyers involved, Rosemary Alito and Nancy Erica Smith, are involved in this litigation. And one of the things we discussed with them is the difficulty in these kinds of cases, because frequently it's a one-on-one confrontation and there are no external witnesses who can come in and resolve it. No cameras, no microphones. And this is that kind of a litigation. It'll be interesting to see how it resolves itself.
So it is the ultimate he said, she said situation. When a jury has to decide, obviously very difficult thing to do.
Extremely difficult, maybe the most difficult that the law requires.
And in fact, sexual harassment is one of those areas where it can be hard at times to know, is it or isn't it? Did it really happen or didn't it? But the stakes can be even higher, the confusion even greater on another front, domestic violence.
He hit me. I can't live like that. I'm afraid. I'm afraid. I'm afraid to leave. I'm afraid to stay. I want him to go. I'm going to have my sister stay with me. I'm so upset. He punched me. That's no way to live. You don't hit people. Yeah, we had our share of arguments over the years, but now, you know, who knows? Maybe he'll really hurt me one day, and then what? What am I going to be, like in the newspaper, like a statistic or something? I just want him out. I can't live like this.
In our imagined scenario, a real retired judge had some trouble deciding just who was telling the truth. And since then, a jury in Texas was in the same kind of bind in the domestic abuse case against NFL quarterback Warren Moon.
In fact, the Moon case was so interesting. It's one I think could not have happened quite that way in New Jersey. A Texas law says that a woman can be compelled to testify against her husband, and in fact, Warren Moon's wife was. She told the jury, hey, he never hit me. Nothing happened. The jury believed her. Where does that leave domestic violence now?
Well, she was obviously a reluctant witness, which had to be a significant factor in his acquittal. It's one of those kinds of legal conundrums to which we've tried to bring a rather simplistic approach, as I think our guests discussed when we talked about it before. Obviously, there are some cases where women need to go ahead, even though they're reluctant and fearful. Perhaps others where counseling or other kinds of remedies are appropriate, but nobody's given it enough time or enough resources.
The Moons say that, in fact, they're suffering from the O.J. syndrome, that's really the reason why they were pressed into this. Feminists are saying that there's been a great disservice done to women who are really victims of domestic violence. And our show on another part of family law centered on a controversial bill now pending. Our topic was adoption. Our focus, a law that would open access to birth certificates for adopted men and women like Barbara Cohen.
It was a black market adoption. Yeah, it was passed by doctors and lawyers, and within 2 weeks, the adoption was finalized back in 1942, and I was passed for $10,000 in 1942.
By the time she finally got her answers, her brain-damaged child had died, and Barbara Cohen had rolled the dice 2 times, giving birth both times to normal children, against what she would later learn had not been good odds.
My brother and sister had children that they lost from the same condition. My grandmother lost a son, and my great-grandfather lost 5 of his 6 children from the condition back in England.
Cohen says it all would be somewhat easier today.
There's a bill in Trenton, and it's been reintroduced, and it's a bill to give access to adoptees 18 years of age and older, that they would have access to their original birth certificate. And this would allow them, if they need it and if they want it, to have their identity, their birth identity.
Cohen and her colleagues in the adoption rights movement have been trying for years to get access to birth records, but they insist this year they have a real chance of passage. They say public sentiment and maybe legislative support has finally shifted in their favor.
But Ray, no legal question or case has stirred more public feeling than the O.J. trial and verdict, and we haven't seen the last of the fallout. It's raised new questions, for instance, about what made us all such experts on that trial, that is, the ever-present camera in the courtroom.
Jury in the above entitled action find the defendant Orenthal James Simpson not guilty of the crime of murder.
Still, for New Jersey viewers, the televised trial is nothing new. The camera came to the courthouse in 1981 with the blessing of the state Supreme Court. The result, mass viewing of moments like these.
I shot George Malaban 5 times. It was due to business.
They hit him over and over and over, cracking and crushing his skull.
We, the jury, find the defendant not guilty.
Shot in the back. Won't let this man walk. No justice in this world. None.
But the judge still has say on keeping cameras out, and the latest so-called trial of the century may have led some judges to think twice.
In a case which was a high-profile case, I might give some more cause. The thing I would evaluate is what would be the impact of the cameras, still or video, upon the process.
The O.J. trial, meanwhile, has California second-guessing itself. Menendez wasn't televised this time, neither was Snoop Doggy Dogg. And even here in New Jersey, a state Supreme Court committee has just recommended a new study of cameras and their impact on the process.
Okay, so judges are becoming more cautious. We've seen that in California of late. But is it going to really, the heart of the question, is California going to make some change in the rules?
This is a small ripple, not a sea change. California has just had a study recommended to the legislature that perhaps pretrial proceedings shouldn't be televised. But courts will remain open to cameras there. Massachusetts Supreme Court has recently encouraged judges to let them happen. And right now, unprecedented, a federal proceeding, a hearing in a civil case in New York, is being televised.
Let's get back to California for a minute, though. The way that we all were introduced to the courtroom, not Judge Ito's courtroom at first, but the courtroom in the O.J. case, was in that preliminary hearing. We won't see that in California again.
Well, we don't know. The legislature still has to act. There'll probably be some more argument and further back and forth on that issue. Certainly the thinking there is that you don't want to have people who are potential jurors hear all the preliminary proceedings and then have to pick a jury, which in a widely known case could be a real problem. But I'm not convinced that the California rules are going to be changed permanently. And if so, it's not a major change.
Let me bring you back to the federal rules. We had federal tests. They decided, the court, that in fact there wouldn't be cameras in the federal courtrooms, and yet you on Court TV just covered the first, since then, cameras to go into a federal courtroom, a civil case.
Well, that process reflects the continuing controversy in the legal profession. There's a judicial conference, all the federal judges in the country. They had a committee that studied the camera issue for a couple of years, and in 1994, that committee recommended that cameras be permitted, at least in civil cases. The conference rejected that recommendation, but local rules in some districts, as in the District for New York, still permit an individual judge to make a decision. And here's a case that involves tremendous numbers of people. It involves the Child Welfare Agency of the City of New York, and a claim by plaintiffs that hundreds of thousands of children have been neglected and not cared for. So that's obviously great public interest.
So the judge said the greater good is to have the camera in. Does this open the door for more and more judges to say greater good, more coverage, more cameras, despite O.J.?
Well, I hate to revive something like the domino theory, but I certainly think there will be other judges who will take heart from Judge Ward and may be more inclined in cases of great public interest to open the doors to cameras.
On the criminal side, no such option.
The criminal side is a whole different genre. I think it's going to be continued debate, and I think it'll be a while before cameras in the federal courts are open in criminal cases.
In New Jersey, do you have the sense, as you go into court, that judges are either more anxious or more cautious in the wake of O.J.? It so consumed the American airwaves, and many people think to the detriment of justice in that case.
Well, I think O.J. did two things, one good and one bad. It made every judge think hard about the question of whether having the camera might affect justice. On the other hand, it spawned an awful lot of nonsense about what a terrible thing happened in California, and somehow that terrible thing, meaning dissatisfaction with the verdict or criticism of Judge Ito, means the camera should come out. And most of those arguments are spurious and probably aren't going to carry much weight. Interestingly enough, though, Barry Scheck and Judge DeGisi, who had been guests on our first show, really thought that while the cameras had an impact, they ought to stay where they are.
Interesting, though, Judge DeGisi, who did the Teaneck trial, which we saw in the little package that we ran, said that he thought that, in fact, a riot might have been prevented in Teaneck because cameras were in his courtroom. An enthusiastic endorsement of cameras in that case.
Well, he was my guest, and I couldn't interrupt him. I don't think I agree that it had that profound an impact. I do think that it is more helpful for people to see the things that they're going to debate about. If legal process is going to be the subject of continued debate, and certainly the subject of continued political action, the more people see, the more they're likely to be able to make informed judgments.
Well, Ray, courtroom cameras were where we started this season, so it is only fitting that we end here for now.
But if you missed any part of our last 15 weeks, you can catch us in reruns for the next 16 weeks. And we'll be back next season with an all-new series on law and justice and, of course, due process. Until then, for Sandy King and all of us here, I'm Ray Brown.
Is better than being in, but it's not easy.
I have a dead little girl because somebody couldn't control himself. Not only did he rape her, but he murdered her.
I got on death row. Everybody was saying to me, you know, you're going to be executed right along with the rest of us.
My life has become defined by that particular week. It seems like now I'm the judge who got arrested in Bloomingdale's.
Joe, please don't start with me. Not on a Monday morning, and I have got tons of work to do.
I'm afraid. I'm afraid to leave. I'm afraid to stay. I want him to go.
We, the jury, find the defendant not guilty.
Sometimes the most unpopular causes are those causes that you have to take up. Because if you don't do that, then the whole system means nothing.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.